Hello everyone, welcome to Tathastu and welcome to our daily news analysis wherein I'm going to present the analysis of the news of 17th of August 2023. So before proceeding ahead, we will check out that what are the topics which we will be covering in today's class. So let's check out the table of contents. The very first topic is Supreme Court unveils handbook to eliminate gender stereotypes from the law. What are those kind of words which the Supreme Court is actually saying that we are not supposed to use? We means the judges and all. Okay, so we will check this out. Next is an act of cement digital authoritarianism. So we will check out this as well. And the another one is new bills and a principled course for criminal law enforce reforms. These are the editorials which we will be covering. Next is the understanding the Ministry of Environment, Forest, Climate Change. So this ministry's U-turn, this U-turn is related to what? We will check this out. Next is the Bihar's caste-based survey, that what this survey is all about and why there is a controversy related to this thing. So we will check out this particular news as well. Both of these are from the text and context part of The Hindu. Next is the Vishwakarma scheme bill, a scheme which will aid 30 lakh artisan families. So what is this Vishwakarma scheme and who will be covered under this? Another one is want to catch supernova. You want to catch supernova, then how you can do? You can do it through the app. And what is that app? What it is all about? We will check out this one. This is under science page, science second page, which obviously you can get it from the e-paper itself. And the last one is the Lake Titicaca. Why it is in news, where it is, it falls under only one country or two countries, what are the significance of this? We will check this out. So these are the 8 news which we are going to cover in today's class. So the very first one is the handbook which has been released by Supreme Court, and this has been done in order to eliminate gender stereotyping. So this is actually being done. See, many a times we see that we get to know or listen this thing that women, they are naturally very emotional, naturally they are very weak. So these kind of the statements we actually listen every then and now, right? So those kind of stereotyping should not be done, and that is what the Supreme Court is saying. And there are a lot many words also which here it is being said that we are not supposed to use it. Okay, first of all let me show you one of the judgment. In one of the judgments, what was actually said in So here it has been said by the Kerala High Court in 2017 judgment, and the judgment was that a girl aged 24 years is weak and vulnerable, capable of being exploited in many ways. What is this? 24 years old girl is being said that she is weak and she can be manipulated, she can be exploited in many ways. So this is actually a kind of generalization, stereotypical thought which is actually being presented over here. So this was actually said in a judgment in 2017 by Kerala High Court. This was actually being said. You cannot say the same thing for 24 years old man. Okay, so related to that man, you cannot say that, but the same thing, but this kind of thing is being said. So all these kind of things, when you listen to all these kind of judgments and all, so obviously what people will be thinking, people will be like that, Are the court also said like this, right? So those are the kind of generalization or the stereotypical thought process. So those kind of things are supposed to be avoided, and there are a lot many words also which we are supposed to avoid. So that is the reason why this handbook has been actually unveiled. Okay, so career woman, fallen woman, faithful or obedient wife, eve teasing, hermaphrodite, the Supreme Court has actually identified these words, and there are a lot many other words which the Supreme Court has actually said that these are gender unjust. These are gender unjust terms that are often heard in Indian courts, and which the courts are supposed to avoid. So this is what actually has been said by the top court. The top court offered the correct terms over here instead of using all these things. Career woman, what is this career woman? Woman is a woman. What is this career woman? Now, woman, wife, street sexual harassment, intersex, all these kind of words actually the Supreme Court has actually suggested that this is supposed to be done. Now, this handbook is of the 30 page, and what is the name is Handbook on Combating Gender Stereotypes, and it actually aims in order to free the judiciary and legal community from mechanical application of the gender stereotypical language in the judgments, which is actually being in the judgments as well as the orders and the court pleadings as well. So these are some of the reasons because of which the Supreme Court has actually said that we are supposed to avoid all these words. Okay, now here I will be showing you a few of the words also which they have actually changed, but before that a little bit of more information. Like here it has been said that the handbook deals with the so-called inherent characteristics of the women, that if you are a woman, if you are a girl, then definitely all these kind of things, characteristics will naturally be within you. But this is not necessary. This is not necessary that every woman, every mother will be a loving mother. Okay, this is not necessary. This is not necessary that every woman will be a caring woman. This is also not necessary. Okay, so this is these are the kind of things which are actually already in our mind, that if she is a woman, she is a girl, she will naturally will be having caring mode on all the time. But that is not right. Okay, so that is not right. So called inherent characteristics of the women, by it is actually striking that. Now, one of the identified stereotypes is the idea that women are overly emotional, illogical, and cannot take decisions. Mind it, all these things has been is actually coming from the Supreme Court. Okay, now the reality is that a person's gender does not determine or influence their capacity for the rational thought, and this is what is actually being said through the handbook. So this is really very good thing which they are pointing it out. Now, it also refers to the assumptions made about a woman's character based on her expressive choices, just like that of the clothes. Okay, the kind of clothes she is wearing. You cannot point out that this if someone is wearing Western dresses, it doesn't mean that that person will be characterless only. When it comes to that thing, then every male is actually wearing the Western clothing only. When it comes to the shirt, pant, jeans and all those are traditionally not Indian attire. But it doesn't, you cannot say that every male, all the male are like characterless, they don't have these kind of things within them and all. You cannot say that. The same thing applies over here also on the woman as well. So when it comes to the expressive choices, you cannot actually point out on her character like through the kind of clothes she is wearing and her sexual history as well. Such assumptions may impact the judicial assessment of her actions and statements in a case which involves the sexual violence also, because if these kind of stereotyping is being done, then definitely the judgments will also be affected. That will be done because the argument will be presented in such a way that this girl, this lady has always been wearing really very Western kind of dresses and all. So that was very natural that she was actually attracting the attention of the other person or the culprit which is standing in the other which is actually standing over there. I'm actually presenting you the quote scenario. Okay, you cannot point out that thing. So that is what is actually being said over here, that if someone is wearing western dress, it doesn't mean that that girl is actually characterless. You cannot point out on her character related to that. And the and especially it is pointing out the sexual violence over here. For instance, they diminish the importance of consent in the sexual relationships, because the consent is the one which matters. Because if two people are having the sexual intercourse, then the consent is the one which actually decides that whether it is a rape or it is not. If the consent is there, then it is not a rape. But if the consent is not there and you are pushing yourself on her, then definitely it is a rape, right? So that is what it is actually saying over here, that these kind of stereotyping and these kind of things actually, these kind of words actually impact the consent thing when it comes to the sexual relationships. Apart from that, the quote also said about that these stereotypical language may reinforce the ideas contrary to our constitutional ethos, because when it comes to the constitution or when it comes to the laws, it actually doesn't talk about any kind of your dressing, your the kind of the way you walk, the way you talk. It doesn't talk about that thing. But what is wrong and what is wrong, what is wrong and what is right, on the basis of that only the judgment is supposed to be presented, right? Now the language is critical to the life of the law. Words are the vehicle through which the values of the law are communicated over here. Words transmit, always remember, because this is something which is being said in Hindi, कि जुबान से निकली हुई जो बात होती है वो तीर के जैसे होती है, वो एक बार निकल गई वापस नहीं आ सकती. Okay, so it's like that only. Words transmit the ultimate intention of the lawmaker or the judge to the nation. However, the language a judge uses reflects not only their interpretation of the law but their perception of society as well. This has been said by CJI, our Chief Justice of India, D.Y. Chandrachud. So he is the one who actually said this thing. So words matters a lot, because the way you are talking and what all words you are using for someone actually tells that what is your thinking, how you what is your thought process related to something. So here, especially when it comes to the lawmakers and the judges, these words matter. These kind of sentences, the words matters when they are using all these kind of things. Okay, now here I have actually included both the things. This was of the Hindu and this is of the Indian Express. I had included both of them over here. So here the handbook actually argues that the language judges use reflects not only their interpretation of the law but their perception of the society as well, because that judge is coming from our society itself. That person is not some alien or somewhere from somewhere else. That person is not coming, but that person is coming from the society itself. So the kind of word which is actually being used by the judge, obviously it actually sets that what is the kind of perception over there in the society, and as well as the judge is actually someone who is sitting over there, and by sitting over there on that particular chair, that person is actually interpreting the law, that our law is actually talks about this thing, or our constitution talks about this thing. So that particular chair holds a really very high position. People look at those people, right? So this is the reason why with the kind of language, the kind of words judges are actually using, those matters over here. So here the language is something which is really very critical over here. Alternative to stereotype promoting languages. So here are some of the words which they have actually, where in the handout they have said that we are supposed to use these words instead of these. Okay, like affair, the kind of word which was actually being used. So here it is being suggested instead of that, relationship out of marriage can be said. Who is mistress? Woman with whom a man has had romantic or the sexual relations out of marriage. And here the unwed mother is a mother itself. It's not unwed mother, or a mother is a mother. Violated, sexually harassed or assaulted, or that of the rape. Eve teasing, so eve teasing is street sexual harassment. Housewife, homemaker. Feminine hygiene products, that is the menstrual products over here. Child prostitute, child who has been trafficked, because the child never chooses, no one actually chooses in order to do these kind of things. Concubine or keep, woman with whom a man has had romantic or sexual relations outside of marriage. Dutiful wife, faithful wife, good wife, obedient wife. What is all these kind of things? A wife is a wife. Prostitute, sex worker. Provider or breadwinner is the employed or earning person. Provocative clothing or the dressing. What is this provocative kind of the clothing and all? Someone, a male, if you are seeing someone, a male actually wearing shorts, you won't be looking at that person over again and again and again. What kind of clothes this man is actually wearing? But if the same thing is being done by the woman, then that is the provocative kind of clothing or the dressing. But there is no such thing related to that. Apart from that, the judges or the people, the society, are supposed to use the word clothing or dress. Sex change is the sex reassignment or gender transition. Spinster is the unmarried woman over here. So these are the kind of words which are supposed to be used instead of the other ones. So that was really very good and huge step taken by the Supreme Court. Now the next, and this is really very important, governance, government schemes, governance, government scheme, polity and all these things are very important, and apart from that, the society point of view also, this is important. Vishwakarma scheme will aid 30 lakh artisan families. 30 lakh artisan families it will be doing. So now we will be checking out about related to this Vishwakarma scheme, which has been announced by PM Modi on the Independence Day. Yesterday also we had actually covered this thing, but today also we will be doing this. Why? Because a little bit more detailed information has been provided. So Pradhan Mantri Vishwakarma scheme with an outlay of 13,000 crore rupees has been announced, and it will be available for traditional craftspeople and artisans from 2023-24 to that of 2027-28. So for really very long period, this particular scheme will be there for the traditional craftspeople and the artisans. Apart from that, what this scheme actually aims at? So obviously the aim of the scheme matters a lot. This aims to strengthen and nurture the Guru Shishya Parampara, that is the teacher-student tradition, or the family-based practice of traditional skills by artisans and the craftspeople working with their hands and the tools. Okay, so something which has actually been inherited from our purvats or the ancestors, which was passed from one generation to another generation. This has always been done. So that is what, those are the kind of artisans, those are the kind of traditional skills which will actually be promoted and which falls under this particular scheme. This scheme also aims in order to at improving the quality as well as reach of the products and services of artisans and craftspeople, and to ensure that the Vishwakarmas are integrated with the domestic and global value chains also, so that their products could be sold or exported to the other countries as well, so that they would be able to make good money out of it, right? So this is what it is being said. 18 traditional trades such as carpenter, boat maker, armorer, blacksmith, hammer and tool kit maker, locksmith, goldsmith, potter, sculptor, stone breaker, cobbler, mason, basket, mat or broom maker, coir weaver, traditional doll and toy maker, barber, garland maker, washerman, tailor and fishing net maker. all these kind of artisans will be covered under the under this Vishwakarma scheme. Okay, so please do remember that these are the artisans or the craft persons who will be benefited. Now when it comes to this particular scheme, artisans and crafts people will get a certificate and ID card. They will be getting certificate and ID card, credit support up to 1 lakh rupees and 2 lakh rupees. So first part, in the first at first 1 lakh rupees will be released, and then 2 lakh rupees will be released at a concessional interest rate of the 5%. Okay, but before that they will be issued with the ID card also, so that the government and the people would be able to identify them. Now there will be two types of skilling programs. One is the basic and the another one is the advanced under the scheme, and a stipend of 500 rupees per day will also be provided to beneficiaries while undergoing the skill training as well. So this is what is related to this particular scheme, and this is really very important one as well. Next topic comes, it is related to the recently passed digital bill, right? So digital data bill, an act to cement digital authoritarianism. So here the digital authoritarianism is actually being holded by the government, because the government is actually coming up with all these kind of things that yes, these can not do, those can do, this can be done, that can be done. These are the kind of companies which are actually which won't be allowed in order to fetch data, wherein the data can be stored, where it cannot be stored, in which countries it can be stored, where in which countries it cannot be stored at all, whatever the case may be. But here all the kind of things, all the kind of information can be fetched by the government, and it will be done, right? And that is the reason why you can see that this is the reason why it is actually saying digital authoritarianism here. Who is doing that? So that is actually being done by the central government. Okay, so the central government is the one who is actually having all the kind of control over here when it comes to the data. Now when it comes to the data protection, protection is just a myth. It is never being protected. Just to give you an example, like the kind of information which you are providing over there on your Facebook, or the kind of information which you are providing over there on the Instagram, or anywhere, any kind of social media, wherever you are, the kind of information which you are actually providing, that is being used by those social media platforms in order to make money. Just for an example, there is a beauty product, okay, and the company actually wants the information related to those people who are very much interested in the beauty products. Okay, so here they might ask, just for an example, they are coming and asking the Facebook, this particular platform, that would you be able to provide us with the information who are very much interested in data. So here in this the makeup products and all, okay, so beauty products. So the Facebook will say yes, I have all the kind of information. There are a lot many people who keep on posting related to their makeups and all, the makeup products and all, so beauty products and all. They keep on doing that. They keep on talking about that. They keep on sharing pictures, photos related to that. And apart from that, they keep on posting the posts related to all those kind of things. So we have all the kind of information. We have the kind of information, even in this kind of information also, that who are above 30, who are below 30, who are above 50, who are above 60, who are below 30, below 20, not below 13 is not allowed, but still students are actually using. Okay, that's a different thing. So here, who are below 20, all these kind of information. What are your criteria? What age group you are actually targeting? You just ask those kind of information, we will be providing you. And in order to get those information, that beauty product maker will be paying money to the Facebook, right? So this is how the data is actually being transferred, and all of a sudden you will see that there are lots of ads which is actually related to some kind of beauty products, and you will be seeing that over there on Facebook as well as over there on the Insta as well, okay, even in your messenger as well. So everywhere you will be seeing those kind of ads, right? So this is how the data is actually being transferred from one place to from one platform to the other platform. Now all of you must be remembering, you people can remember one thing also, that is related to the Arogya Setu. Okay, Arogya Setu. Arogya Setu was a platform wherein the data was actually related to this thing, that whether you are vaccinated or not. Another one is the COVID data, COVID platform also. And you people can recall this thing, that COVID data was actually leaked, right? So that was actually supposed to be very much protected by the government, but that was also available over there on Telegram. Just imagine, Telegram it was available, and Arogya Setu. Now here in this one, the author is actually pointing out how does this Arogya Setu actually helped you out in order to get the to protect you from this COVID thing, how it actually helped you. But here it is being pointed out that though we don't have any kind of information that whether it was actually helpful or not, but this is obviously very much sure that the government was able to get the information related to this thing, that how many people are actually having this Arogya Setu and whether they are using it or not. Okay, and everything related to your vaccination, those kind of data was also being provided. Okay, so COVID platform is the it is the one wherein your Aadhaar, your vaccine related information was over there, right? So all these kind of apps is actually apps are the one which is being pointed out by the author, that how it was actually very much helpful to the people, how it was done. Okay, so here he highlighted the government's approach in order to data protection as a secondary to digital initiative success. Okay, so it was actually, here it is being pointed out that Arogya Setu and COVID, these are the apps which were there in order to make appear India more digitalized. Okay, so it was actually being done in order to make the digital initiatives very successful, to make it appear that yes, it is really very much successful and all. But here when it comes to the data protection, it was secondary. That is the reason why the data was leaked over here. Okay, now these apps raise concerns about the privacy breaches, mandatory usage, and the government's focus on data collection as well, because the government is if not any company, but the government is having all the kind of information over here related to your vaccination on. The smart cities missions delayed implementation and the lack of perceived improvements in the safety and efficiency question the effectiveness of these digital deployments which is actually being done by the government. Apart from here, one thing is actually is also being pointed out by the author, and that is related to the surveillance. The government's partnerships with the surveillance capital and surveillance welfare highlights the expansion of state power at the expense of the citizens' rights. So what is this? That where is the privacy thing? It is actually being pointed out, where is this privacy thing? It is not there, right? So here the government is the one who is actually breaching all these kind of things. So this is what the author is actually pointing out. Apart from that, the mass surveillance and the legal exceptions which is being done by the government. Here all of you can recall one thing, that recently it was in news that China is actually scanning everyone's face, every citizen's face and everyone. Okay, so the same thing is supposed to be done by the government, Indian government also. They are also planning in order to do this thing, and they are planning in order to do this thing on the name of the security, internal security for this particular purpose. So here the government's initiatives for mass surveillance, just for an example, social media communications hub and the national automated facial recognition system are facilitated by exceptions within the Data Act. That with this, when it comes to this Data Protection Act, which was recently adopted, it was passed obviously, so it became act. The bill became act. So here it is being said that for the facial recognition, you are actually infringing the privacy of the individual, all the citizens, everyone's privacy you are actually infringing over here. But here you have made some kind of exceptions. So the exceptions on the willingness of the government. So this is what is actually being pointed at, that why there are exceptions. Okay, now these projects compromise citizens' privacy and gather personal data for questionable purposes also, that why you were going there, why you were doing this, all these kind of questions can be asked. Now the act imposes fines on marginalized groups for incomplete or incorrect data submissions also, that if you are submitting the incorrect data, then the fine will also be imposed on you. Now the trust and the constitutional concerns over here. Here the government is the government's argument for trust and new social contract through the Data Act is very much skeptical. I mean skepticism. You can see it with this thing only, that why you are not actually giving some kind of satisfactory information. You are not doing that, right? Now the vague nature of the act and its potential for partisan manipulation suggest it may appeal more to political ideologies than that of the constitutional principles. Apart from that, this particular perspective disregards the erosion of democratic values and the creation of the authoritarian databases through the recent legislation. So these are the kind of things which is actually being pointed out by the author, and with those are quite good also. These are the kind of articles which actually help you have the negative points also of the acts. Okay, now the Data Act's implications extend to the private sector's role and the government's financial objectives also, because the government, they can actually let go your data when it comes to the finances. They can sell it to the private companies. So this can be done for the financial purposes. This is the reason why I kept on saying this thing, that in today's era, in today's time, this data is actually something which is gold. Data is something which is priceless. You cannot just take it very lightly. Data is something which is even more precious than your gold, your diamond, your rubies, everything. So here for the financial objective, the government, they can actually sell it out. Act's regulatory framework labeled as light touch regulation actually grants a significant ministerial discretion, allowing the government to control data practices. The Act's influence on the economic liberty and the government's potential to sell citizens' data raise concerns about the concentrated state control and the market distortion which can be done by the government and the company which will be buying these kind of data. So here, when it comes to the Digital Personal Data Protection Act of 2023, there are a lot many things which are actually raising concerns, the questions on the intentions of the government and the kind of economic rights, privacy right, the citizens' rights and all those kind of questions are being questioned over here under this particular act, and this is the reason why it is very much controversial as well. Now, let's move on to the next topic, and next topic is the new bills and a principled course for the criminal law reforms. So recently I have told you in one of our, I actually discussed this thing in one of our DNA itself, that recently government has actually planned that they will be making changes in CRPC, IPC and the Evidence Act. So in all these three things, they will be actually coming up with the new act, the new rules and all. Why they actually did this thing? Because there were these were the kind of rules, regulations, or you can say the kind of laws which were age old, 1860s, or these were of those times when the Britishers were there. So Britishers era laws we will continuing even now when we became independent, and it was very much necessary in order to overcome, in order to obviously repeal these laws and all. Okay, now there were three bills which has been introduced by the government, and these aim to transform India's criminal laws, and these has actually sparked the various kind of reactions from the people, emphasizing the need for productive debates over here, which is very obvious. Now these bills replace key components of the existing law legal framework, and which has been in place for over a century, and even more than that, not just a century only. So here these bills have the potential in order to reshape the future of criminal law in our country, which we had already discussed, that what are the kind of things which they will be doing. Like if you are having if you are having physical relationship with a woman on the pretext of marriage, then you will be charged if you are not doing that. So here the criminal law principles serve as a battleground for contrasting perspectives over here, harmonizing the diverse opinions of polarized public views and the government interests, and these are the kind of things which are formidable challenges over here. The historical conditioning of stakeholders and officials by the Macaulay era criminal law spanning 163 years add the complexity of reforming these criminal laws as well, and all of us are very much aware of all these kind of laws which were already there. Okay, no issues with that. Now here initial impact and the future prospects related to these bills. Now these bills has been presented over there to the parliamentary committee. Now in the next session, which will be of the winter session, then it might be presented all over again, and then it will be discussed all over again. So these are the kind of bills which you can write if it is required in your answers in the mains, in the coming mains. But when it comes to the prelims, the bills, questions based on the bills are not actually being asked. It will be asked if it is being signed by the president and it becomes the act, then only. Now but you need to have the kind of information related to all these kind of bills, so that is why I'm discussing over here. Now while the long term impact of the bills remains uncertain, their success or failure hinges on their conception, formulation, resilience, and forward thinking also. Now although the proposed changes might seem significant, they are relatively modest when compared to the deeply rooted challenges facing India's criminal justice system. Now the balancing polarized views over here, the polarized kind of things which is actually being talked every then and now. The bills aim to strike a balance between varying opinions, rejecting extreme kind of characterizations like that of the draconian kind of things for a more measured assessment, gender inclusivity, replacement of outdated terms, reconfiguration of punishments, integration of technology, and innovations like trial in absentia. Even if you are not there, then also the trial can be done on you. And community service are notable kind of features which has been added in these bills. The bills also address the concerns like that of the sedition, and it has been said that it will be repealed completely. Terrorism, they have defined terrorism, organized crime, and even mob lynching as well they have defined in this thing. Okay, now the evaluating the reform process. Here evaluating the criminal law reform process goes beyond just the assessing it immediately. The focus should be on whether these reforms uphold the it upholds the fundamental principles of the criminal jurisprudence and the protection of individual rights, balancing state security imperatives with individual liberties, preventing potential misuse by officials, and addressing systematic deficiencies are the crucial aspects over here. Right. Now, the creation of offenses should be based on the principled examination of the harm or more legal or more moral or legal offense caused by the criminalized conduct over here. And here a lot many things they have pointed out related to the marginalized and the vulnerable populations. They will be ensuring the equality and the equitable kind of treatment to all these people, whether it doesn't matter that from where you are coming from. Now, building the public trust and the implementation. So here they are trying to bridge the gap between the rhetoric and the reality, and these are the kind of significant challenge when it comes to reforming the criminal law. And here it is being said that they will be doing this thing. Now, the criminal law has been used as a strategic power asset by the state, often wielded preemptively, and this approach raises concerns related to the concepts of the risks, endangerment and the dangerousness in criminal jurisprudence, which can impact the individual's rights itself. Just a few minutes back only I saw one news which was there, and it was related to this thing that one person was released on the basis of good behavior. The person was actually released on the basis of the good behavior, and that person was there in the jail on a rape charge, and when he was released he did it again. So here the kind of laws we are having and the way the criminals are actually being released, those are the kind of things which are being questioned over here. And when it comes to these kind of releasing or before their jail term, and whether they are actually working on their character or not, all those kind of things matters. But obviously all how you would be able to track, but still it can be made more stringent. So here this bill, these are the bills who which actually are working on this thing. Like apart from that, there it has been said that 90 days was actually fixed when it comes to the this charge sheet, okay, which can be increased to that of the further 180 days, but they have made it compulsory, that it mandatory, that it should be done within these many dates itself, otherwise it becomes a never ending kind of process. Apart from that, videographing or the statement of the victim, the sexual harassed victim is also very much important. Why it is important? Because it might be manipulated by the police in the later days, if what if the victim actually dies. So in that case, though, that video clip will be of utter importance in the further trials, right? So this is the reason these kind of things has been included in these bills. So this is what actually all these bills actually talks about. Khair, whatever the reason, but in the coming days when it will be implemented, when it will be discussed in much more detailed manner, we would be able to know extract more of the information. As of now, you don't have to take much stress when it comes to the remembering all those kind of points and all. Now, the next topic is related to the Ministry of Environment, Forest and Climate Change. They have taken a U-turn. Now, what is this U-turn related to this thing? So recently, I don't know that how many of you actually know this or not. The Project Elephant and Project Tiger has actually been, it was merged. So here they are now taking the U-turn. The Ministry of Environment, Forest and Climate Change recently issued a notification that signaled a change in its approach, establishing the integrated regional offices. Recently they did this thing. The initial plan was to merge the key environmental agencies. They actually thought that why not we merge all these agencies. Now those were like the Forest Survey of India, okay, National Tiger Conservation Authority, Wildlife Crime Control Bureau and Central Zoo Authority. Initially it was done that they will be actually merging all these agencies together, but later on it was dropped because it was criticized in many ways that how could you do this thing, because everyone's work is completely different from the other agency, right? Now the revised notification also proposes the reorganizing existing regional offices, which has raised concerns over the lack of the objective criteria, that what is their objective behind this thing. Initial merger and the criticisms related to that. The initial plan was in order to merge the key environmental agencies, and this was met with the criticism as the activists, they feared it would weaken these organizations, like that of the NTCA, that is the National Tiger Conservation Authority, expressed concerns that it would actually be hampering their independence. So they might lose their independence and undue interference can be done from the other agencies which will be merged. So the proposed merger would have led to the administrative confusion because they won't be having the authority over their work. So administrative confusion will be there, and the decision making autonomy will also be compromised over here. So these were the kind of questions which were actually being raised by the various agencies over here, which were supposed to be merged, like NTCA did this thing. Now the rationale behind the ministry's move, here the ministry actually defended this merger as an effort to enhance the ease of doing business over here, even though the NTCA and the other entities, the other agencies opposed it. They were like, no, we are not supposed to do that. Why? Because, just for an example, when it comes to conserving tigers and when it comes to conserving elephants, both are the different kind of work, and both of them actually include different kind of efforts over here. So this is the reason why it was actually being said that this shouldn't be done. Okay, now the wildlife conservationists challenged this plan in court, arguing against the merger's legality, that how it is legal, right? So they questioned this thing. Now the ministry asserted that the notification did not constitute a merger but aimed to streamline various authorities under 19 regional offices for more efficient functioning over here. So they would not be able to function in a better way. So this is the reason why they were questioning this thing. Now the challenges and the abandonment when it comes to the merger of these. So the technical and administrative challenges were there. Like, just for an example, when it comes to Zoo Authority, Central Zoo Authority, and NTCA, that is the National Tiger Conservation Authority, both work is completely different when it comes to managing a zoo, and when it comes to protecting, conserving the tigers. Both are different work. So definitely if they would have been merged, their aim would have been what do we say over here, their aim might have clashed over here, because their objective are completely different. So this is the reason why it was said that it shouldn't be done. They shouldn't be done. So the technical and administrative challenges were there, like contributed to the abandonment of the merger plans. So this was actually abandoned. This plan was abandoned because of the technical and the administrative issues over here. The critics argue that insufficient thought went into the merging distinct statutory, scientific and administrative bodies, because before announcing this thing that we will be merging all these authorities, they might not have put much of the thought behind that. So that is what the critics are actually arguing over here. The environmental lawyer, like Mr. Ritvik Datta, he expressed that the plan lacked careful consideration and was destined to fail. Even if it was merged, later on it was supposed to be dropped, and it must have happened, if not now. Okay, it is quite good that it was done quite before merging all these authorities. Now the revised notification. Here the revised notification is not talking about the merger, but it is talking about reorganizing the existing regional offices, which has also faced the criticism over here due to the absence of the clear criteria that how you will be deciding that the reorganization is important and how you will be doing this thing. So all these are the kind of questions which are actually being raised over here. For instance, the Bengaluru regional office's jurisdiction would cover regions with varying geographical, geographic and ecological characteristics, raising doubts about the effectiveness of such reorganization over here. Now, apart from that, the impacts related to the Project Tiger and Project Elephant over here. Indian government has actually planned in order to merge Project Tiger and Project Elephant, and here also the concern is being raised related to the autonomy of the NTCA and the importance of the Project Elephant. Experts are again saying this thing only, that they fear the merger could undermine the significance of Project Elephant, which lacks the legal backing, which currently lacks the legal backing over here, because obviously we have always been very much giving the importance related to the tigers. So here the importance of the elephants, the Project Elephant, might be lacking some kind of support over here. So again, the experts are actually saying that we shouldn't be doing this thing. Now, the experts emphasize the need for dedicated and disintegrated efforts in order to enhance the environmental monitoring functions over here, and strengthening the roles and functioning of the regional offices require additional funding and infrastructure support. They are not into the reorganization, but we need money, we need funding, and we need infrastructure, better infrastructure. Decentralized infrastructure is seen as essential for accessibility to regulators and effective legal enforcement as well, right? So these are the kind of points which are actually being pointed over here by the critics. Now, when it comes to balancing the regulatory outcomes over here, so environmental law and policy researcher Kanchi Kohli suggests an internal mechanism to review the actions of these officers and ensuring the regulatory outcomes are balanced, and these do not disproportionately favor any kind of interest over here, and this is the kind of approach which uphold the environmental protection while maintaining the social justice as well. Okay, so here the kind of merger is actually making news over here, that why it shouldn't be done. Okay, so this was related to this article. Next is that why Bihar's caste-based survey facing the legal challenges over here, that why this is actually facing the kind of issue. See, recently, why it is in news? Recently, Patna High Court, there were petitions actually filed in the Patna High Court related to the Bihar government's ongoing caste survey, that it should be upholded, right? So the Patna High Court verdict actually came that it is upholding the Bihar government's ongoing caste survey. And here the thing is that when it comes to doing the surveys and all, so that is actually being done, the census, it is like census only. So when it comes to doing the census, that actually falls under the authority of the central government, but not with that of the state government, right? So this is the reason why it is being pointed out that how could a state government is supposed to do all these kind of things, right? So this is the reason why it is being said as a survey. The word survey is actually being used, not the census, but this is the kind of census only. Well, now what is the caste-based survey over here? Here, the state government on January 7, the state government, that is the Bihar state government, launched two-phase caste survey in Bihar, stating that the detailed information on socio-economic conditions would actually help create better government policies for the disadvantaged groups over here. That they would be able to make better decisions if they will be having proper data related to the disadvantaged section. Fair enough. So they said this thing. Now, so this was actually being done. So the data was actually being collected by the state government, right? Now, when it was in the middle of the second phase, the petitions were filed in the High Court and it was halted. It was halted that you are not supposed to do all these kind of things. The recent High Court verdict dismissed the petitions opposing the move, and the government on August 2 resumed their work all over again on the second phase of the survey. In the second phase of the survey, data related to the castes, subcastes and religions of all people were supposed to be collected from the from the people who are residing over there in the Bihar. Now here it is saying that what is the need of this kind of census? Why we need this thing? The census conducted at the beginning of every decade, like last census it was done in 2011, right? Later on the census was supposed to be done all over again in 21. Every decade, what it is saying, at the beginning of every decade it is being done, right? Last time also the caste this census was done, but that was not released, and it was actually said that the way kind of information was actually collected, the proper information is not there. So the caste based information, the survey, the census is actually being done, but it was dropped later on that it shouldn't be done. Now here every at the start of every decade it is being done and does not record any caste data other than for those listed as the SCs. In the absence of such a census, there is no proper estimate for the population of the OBCs, various groups within the OBCs, and that of the others also, that how many people actually falls under the OBCs. This is actually being pointed out over here. Despite the ambiguity, Union government has categorically ruled out conducting a socio-economic caste census, saying it is unfeasible, administratively difficult. It is unfeasible, administratively difficult, and cumbersome work also, because there are lot many castes, not only one or two, but there are lot many castes actually. So here there was a writ which was filed over there in the state by the state of Maharashtra. The center in its affidavit, when it was done, said that excluding any castes other than the SCs and STs was a conscious policy decision adopted by and this was done since, this is being done since 1951, and that there was a policy of official discouragement of the caste, that if the government itself is doing the analysis of the caste, it means that the caste does matter. Okay, if they are doing this thing, then how you would be able to eliminate this caste thing? So that is what it is being actually said, that we are actually following the policy of official discouragement of the caste, and this is the reason why we are not doing the surveys, the census related to the other castes, despite that of the SCs and STs. The Union government in 2011 had undertaken a survey of caste through socio-economic caste census of 2011. However, the collected raw data of nearly 130 crore Indians were never made public. Just now I told you this thing, that the census was done, but it was never made public, and the kind of reason which was said presented, it was not done because of the flaws in the data. Here it is being pointed out to related to the Bihar's recent move related to this survey by the political analysts. They are saying this thing, that it is actually being done in order to attack BJP. Okay, this is actually being said by the analysts, the political analysts, that it is actually being done in order to counter BJP's Hindutva politics. This is what they are saying, and here they have actually talking about the Mandal politics. Mandal politics. See, there was a time in 1990s when VP Singh's government was there, right? And they knew that they won't be coming back all over again in the central government. They won't be forming. So they thought, in order to, why not come up with something which will actually, shake the base of the upcoming government, right? So this is the reason, this is actually being pointed out, that this was one of the smart decision which was taken by the next upcoming opposition party, right? So here they came up with this thing, the Mandal Commission, and the Mandal Commission actually came up with a report, and in that report they said that the 27% reservation for the OBCs should be provided, that is the other backward castes, it should be done. And in 1992, here, after this Mandal Commission, a lot many riots actually happened. People were demanding the reservation, and then the Indra Shawne and others versus Union of India, this particular case came, and a ruling was done by the Supreme Court over here, that the caste was an acceptable indicator of the backwardness. The recommendations of Mandal Commission were finally implemented, and the Mandal Commission estimated at that particular time, Mandal Commission estimated that the OBC's population is of the 52%. What they said, that it is of the 52%. Though this particular data 52% is debatable, and even now it is being said that whether it is actually correct or not, so it is something which is the debatable kind of thing. Okay, so the opposition parties have continued to demand the caste census, that what it is actually all about, that whether it is actually related to this thing, the census, or not, right? So these are the kind of things which were actually pointed out. Now, why it is being challenged? So here it is being said that the census is actually being done by the central government, but it does not falls under the state government. They also point out that the state government does not have any independent power to appoint the district magistrate and local authorities for collating data without the notification. Now, what is that notification? The notification should be given under Section 3 of the Census Act of 1948 by the Centre. The High Court verdict has also assailed on the ground that it violates the Puttaswamy judgment, as it permits the collection of personal data by the state under the executive order. So for that, the notification first of all was supposed to be done, and then the data was collected. But again, the point is there that they are not empowered in order to appoint the district magistrates and the local authorities. So over the legality of all these kind of things, actually the question is being raised. The High Court had observed that the state is competent to frame a policy for better administration, and that of the policy is not arbitrary. Here the High Court is actually saying this thing, that it is not arbitrary, this is not wrong what they are doing. Besides, the states cannot wait on their haunches for the center to carry out the caste census. They're not supposed to wait. Okay, here what can happen, they can do it on their own. It also dismisses the concerns about right of privacy of those surveyed by referring the triple test requirements in the Puttaswamy judgment. So this is what it is actually being said over here. It is actually raising the kind of question that whether the state government is authorized to do it or not. Here the High Court is saying that yes, they can do that for the better policy and all, they can do these things, right? Now the next is the want to catch a supernova. There is a app for that. Now here this news is actually really very good for the astronomy enthusiast, that there is an app which has been launched, Zarth app, and this is actually inspired by the augmented reality game, that is the Pokemon Go. All of you must have seen that Pokemon. In order to check out that thing, the mobile people used to move from one place to another place in order to catch the Pokemon. So it has actually taken a kind of inspiration from the Pokemon Go, and it enables users to observe the astronomical phenomena, which is the transients, which is known as transients, by merging science and that of the interactive gameplay. And this is actually really very good for those people who are very much interested in the astronomy. Here, when it comes to the universe, obviously looking at the universe is something really very interesting, and people find it really very serene. But it is a realm of constant movement where celestial bodies like planets, asteroids, comets, and stars are in constant motion. Everything is moving. We are finding that as if that Earth is still, but Earth is not still. It is really moving with really very good speed. Cosmic events like that of the supernova, black hole collisions, and stellar deaths shape the universe violent dynamics every then and now, and we are not able to catch up with all those kind of things. We are not able to check out. But here this app is actually helping you out in order to do these things. The smartphones which are equipped with precise sensors and cameras have become really very powerful, and this app can work on that. So several space focused apps are available both on Android and the iOS devices as well, like the Google Sky Map, NASA's smartphone app, and all of these actually offers the features like identifying the stars, which star is what. You can use that for in order to identify the stars, in order to identify the planets, nebulae, and even the images, videos, and updates on the space missions can also be found over there on those apps. Now Zart is has actually been developed by a team which was led by Ashish Mahabal, and they are the one who developed this particular app. And here, by using your smartphone, you can observe, you can participate in the astronomical observations, and this has been built on the augmented reality technology, which is similar to that of the Pokemon Go. Here the Zat receives a daily data from the Zwicky transient facility, a robotic telescope scanning the northern sky. So this is actually being done. Okay, so this is related to this Zart app itself. Now the last topic of the day, it is related to the Lake Titicaca. So first of all, find out that where is this Lake Titicaca. So here you can see this is the South America. Okay, so this is the South American continent, and here this particular one you can find it, that this is the Lake Titicaca. This actually is at the borders, and here it falls within the Peru and that of the Bolivia. Okay, so it comes under the, it actually covers the two countries, that is the Peru and the Bolivia. Here you can see, okay, this is the Lake Titicaca. Here you can find out, here you can check this out, this is the border. Okay, so this is the Lake Titicaca, and here here you can see the Bolivia, and here is the this thing, the Peru. Here this is much better way to find it. Check this out, right? So here you can see this is the border, right? So here is this the Peru, and here you can see the Lake Titicaca. Here it is saying that there is El Alto. This is the place named El Alto, and because of that particular place, specifically because of that particular place, here this particular lake is actually being destroyed. So the Lake Titicaca, which is a vast water body and which is located over there in the Andes, and it is on the border with that of the Bolivia and Peru. Andes, okay. Now Bolivia and Peru, this is actually facing the critical situation. Here the water level is going down, and it is at the water levels are at the alarming low. It is alarmingly at low position, very low, due to the effects of the climate change, and this phenomenon is actually impacting the environment, livelihoods, and the local communities as well. Here it has been pointed out that the water level is at such a low that the boats are actually stranded, and praying, the people are actually praying for rain, so that Lake Titicaca is revived all over again. The lake's water levels are dangerously close to their all-time low, and it has been said, it is being said that it has actually record which was set in 1996, and after that it is the time when it is at really very low. According to Bolivia's weather service, the plummeting water levels in the Lake Titicaca are primarily attributed to the climate change. So here they are blaming on the climate change, that because of this thing only this Lake Titicaca is actually facing the issues. Now because the water level is actually going down, so because of that all the water aquatic animals, they are not surviving, the fishes and all those things are actually impacting, all these are actually impacting the aquatic animals and plants all over this. Now when it comes to the Lake Titicaca, it is one of the largest, world's large lakes, and the largest in the South America. It is at the highest of the world's large lakes. This is the feature actually related to this thing, that the Lake Titicaca is the highest of the world's large lakes and the largest in the South America after Venezuela's lake, that is the Maracaibo, and Brazil's Lagoa dos Patos. So after these two, this is the one which is the largest in the South America. Here the lake's water has actually been fluctuating over the years, but the current situation is really very exacerbated by the effects of the climate change. So climate change is actually being pointed out over here. The declining water levels in this has actually highlighted the urgent global action which is supposed to be taken care of related to the climate change. Nothing much could be done over here. Well, the Amazon Cooperation Treaty Organization emphasized the responsibility of industrialized nations to fulfill their commitments in order to combat the climate change, and that is in order to help out these countries in order to obviously roll back these kind of climate change things which is actually happening. However, in the local villages surrounding Lake Titicaca, there is a growing sense of despair that the water levels may never return to the normal, and people are upset related to this thing. And because of this, all these kind of things, the people are surrounding that area, and even the El Alto, that place, that is all that is actually the metropolitan city, and that is also impacting the Lake Titicaca because of the all the kind of pollution and all which is actually this particular city, metropolitan city, is contributing like that only. Okay, whatever the issue, but here the thing is that we need to save this Lake Titicaca, we need to save this thing, otherwise it will be gone forever. It will be gone forever. Well, so this was it related to our daily news analysis. Hope you people enjoyed it. See you in the next video. Bye bye, take care and have a great time.